Just had a back and forth with Senator Blumenthal, and previously you and Professor Family had a disagreement on the degree of individual discretion that is exercised in these cases. I will note that the federal court in Texas assessed that question. And indeed, in footnote 101 of the federal court's opinion, the federal court observed that the claim of individualized discretion, what the court said is evidence of DACA's approval rate, however, persuades the court that this, quote, factor is merely pretext. And indeed, the court goes on to say in that same footnote, no DACA application that has met the criteria has been denied based on an exercise of individualized discretion. So the federal court heard this argument and concluded, to put it colloquially, it ain't never happened. There is no discretion. And indeed, I would note that as you described the experience of your clients, the ICE agents, it brought to mind what President Obama said on February 25th when he was doing an interview with MSNBC and Telemundo. And the President said, quote, there may be individual officers or Border Patrol who aren't paying attention to our new directives, but they're going to be answerable to the head of the Department of Homeland Security because he's been very clear about what our priorities should be. If somebody is working for ICE and there is a policy and they don't follow the policy, there are going to be consequences for it. Secretary Kobach, does that sound like granting discretion, or does that sound like a not very veiled threat that you will grant amnesty or risk serious employment sanctions? Use your microphone, please.
It's a threat that is not veiled at all, that you will face employment consequences and significant ones if the President of the United States is actually delivering them. And let me give you an example of the perfect case where you might say, oh, if they had discretion, they would have exercised it. One of our ICE agents in this plaintiff group of 10 is based in El Paso. And just to quickly tell the story, the El Paso, this was in DACA, so it was a late summer of 2012. El Paso Sheriff's Office called, said, we have in our jail someone who's been arrested for assault. And we now have, he's admitted that he's illegally in the country. Would you please, ICE, come over and pick him up and remove him, deport him? ICE went over to pick him up. When they took custody of him, he had a scuffle. He injured one of the one of the officer's shoulders, and ran away. They had another fight, again, fighting a federal law enforcement officer, ran away. They finally got him under control and got him into the vehicle. At this point, one of the officers had been severely injured, the other officer, minor injuries. They get him to the ICE headquarters, and they are ordered by the supervisor, as soon as he asserts that he is eligible for the amnesty, turn him go. The ICE officers were in shocked disbelief. This guy had just assaulted 2 federal law enforcement officers in addition to his prior assault that he'd been arrested by the El Paso authorities for. So you would think if discretion existed, well, maybe we'd exercise discretion in this case. The guy is beating up federal law enforcement officers. But no, no discretion was allowed. There is no discretion, certainly at the ICE level, and as the statistics and as Judge Reining reflected, at the CIS level, that agency doesn't appear to have real discretion either.
So am I understanding you correctly that the President's executive amnesty program is so inflexible that a violent criminal who's committed 3 acts of assault, 2 of which are against federal law enforcement officers, has fled law enforcement, is nonetheless forced to remain free and potentially commit more assaults?
He was ordered, they were ordered, let him go, and they were absolutely shocked.
I think that speaks for itself. Let me shift, Professor Family, to a different component, which is the legal justification. Much of the legal justification has been discussed in the context of prosecutorial discretion. But of course, this is far more than simply saying we're not going to prosecute cases, because part of this illegal amnesty is printing up millions of work authorizations and Social Security cards for people that federal law explicitly prohibits working in this country. It is not obviously an exercise of limited resources, because printing up millions of work authorizations cost additional money and additional resources. And when you print a document labeled a work authorization that is prohibited by federal law, that is known as counterfeiting an immigration document. Work authorizations can be printed only pursuant to federal law, and when federal law prohibits someone here illegally from working, the President's order directs that work authorizations be printed nonetheless. All of this is hinged on this wonderfully flexible theory of prosecutorial discretion. And so what I'd like to ask you, because you have also in this hearing defended prosecutorial discretion, do you understand the limits, the theory of prosecutorial discretion to have any limits whatsoever? Is there anything that constrains the authority of this president or a subsequent president to pick and choose which laws he or she will enforce and which laws he or she will ignore?
Thank you, Senator. I think we'll just have to respectfully disagree on our interpretations of what the law allows in this circumstance. So, work authorization for anyone who's granted deferred action is authorized by a federal regulation. So that's legally binding on the Department of Homeland Security. They have to follow that
federal regulation, of course, can't authorize conduct that's prohibited by federal statute.
Well, and that's where I think we have to respectfully disagree about what the statute says. And so the statute gives the Department of Homeland Security delegates authority to decide who will get work authorization, and then the Department of Homeland Security is utilizing that delegation through a regulation to say people who get deferred action can get work authorization. So I think we just disagree on what the Immigration and Nationality Act says.
So if you would shift to the question I asked, which is the theory of prosecutorial discretion. Are there any limits you would recognize on that theory? For example, the president has claimed he has the authority to grant amnesty to some 4.5 million people here illegally. Under your understanding of prosecutorial discretion, would anything prevent him tomorrow from granting amnesty to all 12 million people here illegally? Is there any principal distinction between 4.5 million and 12 million, or does this mean the president has the authority to grant amnesty to everybody?
So let me tell you what I would think about. I would think about, I would look to the statute to see what the statute says in terms of what Congress has delegated to the executive branch. Of course, actions need to be rational, right? They can't be arbitrary and capricious. They have to be principled and they have to be thought through. We can't just flip a coin to decide what the policy is going to be. And so I would look at those things, and then I would also point out that the Office of Legal Counsel memo actually stopped short of saying what I think you're suggesting is just authorizing prosecutorial discretion being authorized for the whole undocumented population. And I think I really do want to emphasize this point as well, that sort of what's at stake here is not a green card, right? We're just talking about revocable permission to be present for a certain period of time. And as a matter of fact, because the Department of Homeland Security did this by policy memorandum, that means that a new administration has great flexibility in deciding whether to continue the program or not.
All right, since my time has expired, I'm going to recognize Senator Coons, and then I'm going to loop back at the end of these questions to finish this chain of questioning, because there's more I'd like to discuss with
Senator
Coons.
Well, thank you, Mr. Chairman.